Your Honor, S24A0599, Cobb County versus David Flom et al. Elizabeth Moniak for appellant, Justin Golart for amicus appellee, and Ray Smith for appellees.
Good morning, counsel, and thank you for being with us. Ms. Moniak, you may proceed when you're ready.
May it please the court, my name is Elizabeth Moniak, and I'm representing the appellant Cobb County. I'd like to reserve 5 minutes for rebuttal.
Please keep track of your time. I'll try to do that for you, but
thank you, Your Honor.
Proceed.
The trial court erred in this case when it ruled that it had subject matter jurisdiction to decide the case. And it also erred in its determination on the merits that the BOC's amendment of HB 1154 was unconstitutional. Starting with the threshold subject matter jurisdiction issues, subject matter jurisdiction is lacking here for 2 independent reasons. One, the Floms have pled no facts to show that they have incurred any individualized harm, and therefore they lack standing to bring their claims. 2, the Floms have pled no facts to show that they're in a position of uncertainty related to future conduct regarding a legally protected right or interest.
So let's take the constitutional standing question first. Why are they required to plead facts to show they have suffered sort of an Article 3-esque injury in fact? They're not challenging a state statute.
Yes, Your Honor, they are challenging the constitutionality of the BOC's amendment of 11...
Which is not a state statute. So why would the standard for standing to challenge a state statute apply?
Under the Home Rule Amendment, when a county governing authority amends a local law, it does remain a local law, and they are challenging that local law.
But that's an act of a county. The case law that supports the idea of this higher threshold for constitutional standing to challenge state statutes comes out of the sort of the respect that the state judicial branch has for its co-equal legislative branch and a desire for comity between branches. The county is not co-equal with the state judicial branch, so it seems to me that case law just has no application here.
Well, Your Honor, I believe there are cases involving challenges to constitutionality of ordinances, and of course, Georgia...
That have actually considered this question analytically?
No, Your Honor, because I was about, obviously for so long we were operating under a higher standard for standing, and then we had the Sons of Confederate Veterans case, which did change the law significantly in that area. Footnote 13 made clear that challenges to the constitutionality of a law remained under the higher standard, and an ordinance is still considered a law, as is a local law is a law. So the county's taken the position that the higher standard applies, and it appears that...
Does the county exercise the state's legislative authority? Because the Constitution says that the state legislative power shall be vested in the General Assembly. It provides there's no provision about delegating the state legislative authority to counties.
Well, when the county exercises its home rule authority pursuant to the Georgia Constitution...
That's county legislative authority, which is not on a par with the state legislative authority, right?
Your Honor, I don't know that I would really agree with that. I think that the Constitution has given directly to counties legislative authority that is on a par with this.
But it is not the state legislative authority, because the Constitution says the state legislative authority is delegated in the General Assembly. It does not have any exception or proviso to that.
But then a different provision of the Constitution gives counties home rule authority.
Which is not state legislative authority.
Well, I mean, some of the experts, such as Professor Santel, have said that when a county is exercising home rule authority, it is on a par with the state legislative authority.
Ms. Moniak, even if that's true, I think the point the presiding justice is getting at is that our special higher standing rule for constitutional challenges to statutes is based in separation of powers, right? The comity for the legislative branch in particular. Can you articulate a theory of separation of powers that requires that same comity between the judicial branch and counties?
You know, Your Honor, I mean, since those arguments have never been made in the lower court, no one has ever, even though the plaintiffs vehemently argued in the lower court that they were subject to the generalized grievance standard, it isn't for any of the reasons that I'm being asked about today. And then in the appellate brief, they seem to have conceded that the higher standard applies.
Right.
So I would probably need to give that one a little bit of thought, honestly, because I don't want to answer that incorrectly. I mean, I think that footnote 13 in Sons of Confederate Veterans, when it said law, and I know for sure that ordinances are laws and have been called laws, our feeling was that that applied to all laws.
Right,
and so that is
but
why we
I guess
argued.
assuming that sort of the traditional conception of separation of powers is about separation between co-equal branches, right? The question is,
Then
those
that
are
would-
laws, but they're a different kind of law.
Correct.
And so how does that
Well, I would
map
agree
onto
with that, Your Honor.
if at all?
I would agree with that, Your Honor, that is a difference, that separation of power argument would be different.
And so that animating principle wouldn't apply here.
Well, unless there's another animating principle, but I would have to give that one a little bit of thought.
That's fair.
Um,
That's fair.
So our second jurisdictional argument, which is one that
Let me
this...
ask this. Under your construction, who would have had standing to pursue a declaratory judgment with respect to this question?
With their standing or the second, or in terms of the harm issue, what we were just talking
Yes.
about, or the future conduct
Yes,
issue?
the harm.
Issue. Who would have had standing? Your Honor, I don't think anyone would have, honestly, because if we are on that higher standard, we're looking for, you've diluted my vote. This is a denial of...
So it's an unchallengeable decision?
Not every dispute has a judicial resolution. I certainly think there were remedies for them. The Home Rule Amendment makes perfectly clear that the General Assembly can carve out new areas of preemption whenever it wants to.
What
And in
about the
fact,
office holder?
I'm sorry,
Would the
what?
office holder of that particular district have standing?
Would the candidate,
Yes.
a candidate have standing to challenge this? Would a candidate have standing to challenge this? Had a candidate who qualified before the map changed?
Well, let's say one who was in office at the time that the map changed.
No, I don't think so. I don't think they would have standing.
Why?
Because I don't think they have that can happen. Your district can change and you are
But if
disqualified.
the question is injury, isn't that the person who's most acutely injured?
I mean, I guess they could argue that they were injured. I guess they could argue that they were injured. I mean, we didn't have that fact pattern here, of
What about the
course.
local board of elections, who would perhaps, I mean, they're presented with two claims of what their duty is. Would they have a potential injury to assert?
No, I don't think so, Your Honor. I don't think they would have an injury at all. The County Board of Elections' duty as an executive agency is just to apply the law.
So
And
there's no
what
one
if
that
they don't
has
know what the law
constitutional
is?
standing.
unless there is someone who can say that this map has diluted my vote or denied me equal protection, if we're dealing with the higher standard.
Right.
Now, this court has raised the issue that perhaps the lower standard applies. And if this were a generalized grievance standard, then I would agree they have standing.
Okay.
And so since
let's
there's-
move then to the declaratory judgment standing question.
Yes.
Because I think there you are on stronger footing. We have decades and decades and decades of case law saying you have to be uncertain about some future conduct and require guidance from the court as to what future conduct to take. I understand your argument to be that regardless of whether there's uncertainty about sort of past rights that have accrued, the county is telling them where to vote, and they don't have any uncertainty as to what action they're supposed to take when election season comes around. Is that your position?
Yes, Your Honor. We don't think their only uncertainty, and they've been candid about this in their brief, their uncertainty is whether that BOC amendment is constitutional, whether the county governing authority has authority under that Home Rule Amendment to amend the law. That's their uncertainty, and that is at request for an advisory opinion
What
from
if
this
they
court.
had instead brought a mandamus claim?
If they had brought a mandamus claim, that...
They did bring a mandamus
They did,
claim,
and
right?
it failed,
And
yes.
it got dismissed.
For failure to state a claim, yes. On numerous grounds, and they did not appeal
But it seems to me, so the mandamus standing that applies is a generalized grievance.
Correct. It was not dismissed for standing. It wasn't a jurisdictional dismissal. It was dismissal for failure to state a claim because there was no public duty, legally required public duty that had been violated.
That seems wrong, right? I mean, if the redistricting was unconstitutional, the county is under a public duty to follow the law, right? And so applying an unconstitutional law would violate a public duty.
Yeah, Your Honor, I would respectfully disagree with that because I think that when a law is enacted, it has to be followed until a court has declared it to be unconstitutional.
Which a
That's sort of
mandamus
a rule of
petition
law
can
principle.
do.
Pardon me?
Which on a mandamus petition, a court can do. If the court concludes, if the mandamus claim is, this law is unconstitutional and therefore it violates the public duty to apply it, in resolving the mandamus claim, the court can conclude that, in fact, the law was unconstitutional.
Well, I don't think so, Your Honor, because I think the mandamus claim limits, you look at, has a ministerial duty essentially not been performed. You can't even direct the exercise of the discretion.
So the question a Board of Elections, County Board of Elections is who gets what ballot, right?
Who gets which?
It's a legal question. Do you live in which district? There are two sets of maps. And I say you have a legal ministerial duty to use the map the General Assembly passed. And you go to court and you get you're seeking mandamus saying, I, as a citizen, am requiring you to use the lawfully enacted map and not the county's map. That would be the nature of the claim in mandamus. And then the Superior Court would mandate that the county office, in this case, the Board of Elections, does or does not have a responsibility to use this map or that. That seems to be cleanly a mandamus case.
So, Your Honor, my perspective on that is that the BOC followed all the constitutional procedures to amend that local law. Now, if they hadn't done so, that would be different. But they followed all the procedures.
That presumes they had authority to.
That presumes the ultimate question, which is what the mandamus would be, right?
I think that to prevail on the mandamus, there would need to have been adjudication on the constitutionality. They would have to challenge the constitutionality first before they could then expect.
I mean, Counsel, as I understand your point, it is that there was a law in the books that clearly said this is the map, right? It was the county's ordinance. And so a mandamus claim, in your view, would not succeed because
they were following
the law as it was on the books at the time.
Correct. That
right?
had to be followed unless and until it were vacated on grounds that it was unconstitutional, which happened in the Superior Court, but then the automatic supersedious was triggered. So I don't think a mandamus claim, I think the Superior Court got that one absolutely correct. It should have been dismissed for failure to state a claim because there was no legal duty. That the mandamus was actually asking the Board of Elections to violate the law and look behind it.
So under this theory, you would have had to get a declaration before seeking mandamus. How can you get a declaration if no one has standing to get a declaration?
If you don't have standing to get a declaration, then an unconstitutional law remains on the books.
So the Board of Elections doesn't have declaratory judgment standing under the facts of this case?
I do not think that county
There's no
board
uncertainty as to who to send a ballot to? There's no uncertainty about who to put on said ballots?
No, I think the County Board of Elections has to administer the redistricting law as it exists. It doesn't look behind and make judgments on its own about whether a law is constitutional or not. It leaves that to the courts to do. That's not its job.
So you don't think the Board of Elections has any independent duty to ascertain the legality, the constitutionality of what is presented to it as the law?
I do not, Your Honor.
Do the members of the board take an oath to the Constitution?
The County Board of Elections. Your Honor, I don't represent the County Board of Elections, so
I know.
I don't want to answer that. I would assume they do, but I'm not. I think that's a statute that requires that, but I don't know for sure.
I mean, it seems to me that would be kind of the epitome of a good declaratory judgment claim. You have one set of maps, and then it's of potentially doubtful constitutionality, And so they need certainty as to which set of maps that they need to implement.
So I don't-
Right, it is seeking prospective relief, and it's seeking certainty as to which set of maps
And,
they
Your
need
Honor,
to.
I would say that would be an impermissible advisory opinion. I think that would be the County Board of Elections, instead of looking to their lawyer and saying, tell me, what's the law? And the lawyer could say, well, right now, they've followed all the constitutional procedures, so this is the law.
That assumes there's authority in the first place. Following procedures only helps if you're exercising authority you have.
Well, I think that issue, they have a right, someone with standing has a right to challenge the
But
constitutionality
you
of
said
that law.
nobody has standing.
Well, somebody who's perhaps a candidate, as Justice Warren suggested, would be someone with standing.
What if the
Or-
statute was just patently on its face unconstitutional? You're saying that the Board of Elections has no authority to try to challenge that with declaratory judgment standing?
I think that puts the Board of Elections as if it's a court. I mean, and many of the
but
people on the
doesn't-
board
Well,
aren't
that's the
even
purpose of the
lawyers.
declaratory judgment statute, is to permit the uncertainty to be resolved, and you're saying they should plow forward regardless?
I don't think the County Board of Elections has the institutional competence, because most of them are not attorneys. In fact, I think only one is, to look back and determine whether the law is constitutional or not. I think they look to courts for that.
If a citizen, accepting where you are in the standing piece, if a citizen is concerned about the maps and they can't file a declaratory judgment, could a citizen, the maps in question purported to take effect January 1, yes?
Yeah.
So could a citizen of Cobb County today file a quo warranto action to get an answer on the constitutionality of the maps and say, by what authority are you exercising the office of commissioner of whatever district, and file it today?
They could certainly file one. I think the answer would be that unless and until this court lifts the automatic supersedious, which the Flomes did file a motion for, the law that is in
Well,
place
no,
is still.
in the quo warranto action, the claim would be the action of the Board of Commissioners to redistrict was unconstitutional. Therefore, the office that is being held under that action is actually vacant.
Yeah.
Well, I think the quo warranto action would look at qualifications for holding office, and the residency requirement would be determined by the applicable redistricting map in place.
No, so a quo warranto action is an action in which the constitutionality of the provision under which the person took office was valid. And I know that because when I was appointed to the Court of Appeals, there was a quo warranto action that was filed that wound up being decided by this court, and the constitutionality of that action was affirmatively determined. It wasn't just look at the face of the statute and decide whether.
Okay, well, if that's the case, then I guess they could have done that, but nobody did do that here.
Can we talk about the merits real quick?
I'm sorry, Your Honor?
Can we talk about the merits real quick?
Yes, I would
Why
love to do that.
wasn't it patently unconstitutional?
Why wasn't it patently unconstitutional?
So the provision of the home rule provision that says counties can't do things that affect an office. It seems to me the most important thing about an office is the people that it represents. When you change who an office represents, why isn't that an action affecting an office?
Well, that would mean anytime somebody moved, they've affected the office, and our courts have
No,
traditionally.
the Board of Commissioners hasn't done that. The home rule provision is all about what the Board of Commissioners can do to a local law.
But what I was trying to explain, I guess I didn't say it clearly, was that if the mere identity of the constituents affected elective office, then one person moving affects
It's
elective
not the
office.
identity of the constituents that's at issue, isn't it? The changing of the map?
Yes, the office.
I thought that the court was asking
And
me.
the answer is, it does change the office, but that is not an action by any government entity. That is a free citizen who moves.
Your Honor, our position on this is that this court has been consistent, and the popular definition at the time in 1965, 1966, looking at that dictionary, defined office in terms of duties, authorities, power, and that's what affects elective county office. The term belongs to the office, not the office holder. There's always been a distinction between the office and the office holder.
And let me say, your brief was very well done, and it did a very good job of grappling seriously with interpretive principles for the Georgia Constitution. I want to affirm that. But this distinction between the office and the office holder, the whole focus on what area a district represents is not about the office holder. It's about the office. It's about the people that the office represents.
Well, that would be contrary to the 1966 definition, which doesn't talk about, it talks about duties and authorities. The fact that some
How is that
beautiful-
not part of the duty and authority? It's a duty and authority to represent a particular district. District changes.
The duties and authorities are set by statute. They're allowed, they can legislate, they can meet with constituents. The different things they do are the same, no matter what that district looks like. And when the state's talking about things
But
like...
the people they represent are different.
But
I mean, that's the core
that's
of
why
any
there's
representative office.
And that's why there is an effect on that office holder. Just like in the situation where we talk about the former...
There's also an effect on the office.
I don't...
And I know this, you're talking about counties, but like in the legislature, your vote for a DOT representative is based on what geography is covered by your legislative district. The interest of the district is based on what area that it covers, and so that's the office, right?
No, that's the office holder. That's the person who has now new constituents and new concerns. But the powers, what they can do, I'm allowed to pass legislation. I'm allowed to meet with constituents. That's the same. And in the
Counsel, I've been terrible at helping you save your time. With the help of my colleagues, I'm sorry, but your time is out, and we weren't able to save you any rebuttal time. But thank you. Thank you.
All right.
for the
Well,
fine
thank you very
argument.
much, Your Honor.
Thank you. Mr. Golart?
Thank you, Your Honors, and may it please the Court. On the merits, this case is all about the division of power between the General Assembly and a county when it comes to drawing electoral district lines. Under the Georgia Constitution, all of that power resides with the General Assembly. Cobb County therefore violated the Constitution when it purported to amend the General Assembly's redistricting statute and replace it with district lines that the General Assembly had considered and rejected.
And just to be clear, you're here on behalf of the amicus Attorney General?
Yes, Your Honor.
Okay,
Here
and you're not taking a position on the standing
We have no
question?
position on standing. We're only here to discuss the merits.
Okay.
And I'd like to start with two preliminary and uncontested points. First, that Georgia's Constitution is interpreted to give words their plain and ordinary meaning, reading the text in its most natural and reasonable way as an ordinary speaker of the English language would. This is especially true in the constitutional context where the people themselves are the makers of the Constitution and not their elected legislators. Second, a lot in this case turns on the word effect. That is a word that drafters use when they intend to sweep broadly, when they intend to include and not exclude. And its definition, both in 1983 and now, is very straightforward and simple. It's to produce an effect on something. So the question here is whether an ordinary speaker of the English language would understand redistricting to affect the office of district commissioner or the procedures by which that officer is elected. If the answer to either of those questions is yes, then what the county did here was unauthorized. The parties and the state largely agree with most of the definitions that are being used in this case. And Your Honors have already discussed the C1 subparagraph. I'd like to talk also about the C2 subparagraph, which is the one that talks about procedures, things that affect the procedures for an election.
If C1 prohibits the action of the Board of Commissioners, does C2 matter?
It doesn't. Well, it still matters, Your Honor. But if C1,
would a court considering the constitutionality of the act have to proceed to C2 if it concluded that C1 foreclosed the act?
But I would like to briefly address C2 because we actually think that may be even the clearer route. The county's own definition of a procedure is a necessary step to conduct an election. So to accept their position, you would have to agree that not only is drawing district lines not a necessary step to conduct an election, but also that it does not even affect a necessary step to conduct an election. In reality, it is hard to conceive of a more necessary step to conduct an election than to define the electorate and decide who's voting in the first place. The county acknowledges that it is statutorily charged, which means empowered by the General Assembly, to do many election procedures, but it also acknowledges that it has no role in redistricting, but it twists these realities to mean that redistricting is not a procedure, when the obvious conclusion is that it is a procedure, it's just one that they are not authorized to take.
So I will say I find that argument a considerably greater stretch than the C1 argument. I mean, I think sort of just the ordinary, and perhaps this is substituting colloquial for ordinary, but when I think about the ordinary meaning of an election procedure, I think about qualifying. I think about all of the various sort of almost ministerial things that go into, we're having an election, we have to have candidates, we have to have voters. Obviously, drawing district lines is a condition precedent to having an election, but I'm not sure that makes it an election procedure.
I think that if Your Honor, takes that view that it's a condition precedent and not part of the procedures, I would respectfully disagree and say that I do think it is part of what is required for the election. But also, as Your Honor was suggesting earlier, then it just goes back to the C1 exception. If
And
you
your
have
argument there would be that, in with respect, at minimum, if it affects a procedure, which is part of the procedure is, we got to have voters, we got to know which ones vote in which district. I mean,
That's correct, Your Honor. And also, I think that it also, just going back to the first principles of the wording of the Constitution here is, I think what it's doing is it's saying this is still with the General Assembly. Counties, this is in the county home rule provision, and it's taking the electoral process and saying this is not what you do. And so I think that.
Let me follow up on that. I mean, we've talked a lot about subsection C and not a lot about subsection A. And there's not been a lot of briefing about that, but it seems to me that subsection A says that a county can pass ordinances which are not inconsistent with the Constitution or any local law applicable thereto. Here, the timing of it was that the legislature passed the districts, and then later the county tried to overturn that. Doesn't subsection A prohibit that just at the outset, like without going to subsection C?
I think that that's possible, Your Honor, but I do think that, from the state's perspective, the clearest way to resolve this case is to look at subsection C, C1 and C2, because what the county did here is very much, I think, right in the heart of what those provisions are.
But thinking about the next case, I mean, if we go to subsection C, would we be implying that counties can just overrule things that the General Assembly has passed? I mean, and that we have to go to find some sort of exception under subsection C to overturn that?
I don't think that that's what would be communicated by that, Your Honor. I think that, and clearly that's not a point that the court should make, but I do think that, under the county's home rule authority, it does have certain authority, and it does have the authority to act when there is no action from the General Assembly or to amend in certain situations. But the important part about subsection C is simply that it takes the electoral process out of what the county is authorized to do.
So is there any situation where the General Assembly can pass a law and the county can override it? Like, is there any situation where that can ever happen?
I think that there are situations in which that can happen, but they are the ones that are, but not in the situations.
Like what? Because, I mean, the subsection A and subsection B talk about the local charters and different, and the local government, the acts, the governing acts of and perhaps the county has authority over that, but just other general law or other local law, can a county override that?
I think that in the Tier 1 and Tier 2 authority that the county has, in Tier 2, it does have authority to amend or repeal certain acts of the General Assembly that are local. And so the issue here is not to say that there is no Tier 1 or Tier 2 authority. It's to say that it does not extend to what the county did in this situation.
You're saying under Tier 1 authority, the county can override the General Assembly? Because the way I understand is that that authority is really limited to their local, things affecting their local governing acts or other ordinances governing local actions where the General Assembly has not acted.
That's correct, Your Honor. And for the state's perspective, in our brief, we accepted that this was the local general distinction as far as the statute goes, because really the point of emphasis is, and I'm sorry to keep going back to it, but is the subsection C, because it just seems so clear to the state under both of C1 and C2 that both the office and the procedures by which the office is elected are being affected by drawing.
And regardless of whether there are other circumstances in which a county can amend or repeal a local act, are you aware of any case in history where a county has changed local Board of Commissioner redistricting that the General Assembly has done?
No, Your Honor, and I don't
So this
think,
appears to be a novel assertion of county power.
yes, Your Honor, absolutely, and it is one that, you know, there was some discussion in the briefs about 2 federal cases in 2002, and clearly those are not precedential in the sense that they do not bind this court, but they're informative in the sense that both of the courts in that case and all of the parties in those cases, including Cobb County was one of those parties in 2002, it was all accepted that the county can't draw their own electoral districts. So, you know, that background assumption and understanding was clear then. It's been, you know, 40 years since the Constitution was reenacted, and this is, as far as the state is aware, the first time that a county has attempted to do this. And I think pragmatically, if you think about the county's position and the fact that, you know, they would say that this affects neither the office nor the procedures by which an office is elected, you would think that redistricting legislation would be anodyne and uncontroversial. It clearly is not. It generates a lot of legislation. It is very important to most people, including everyone in this courtroom today, because it affects the office and because it affects the procedures by which officers are elected. And with that, the state thanks the court for allowing its participation in oral argument and asks that if the court affirms on standing, that it also affirm on the merits.
Thank you, counsel. Mr. Smith?
Good morning, Your Honors, Justices of the Supreme Court of Georgia. May it please the court, I am Ray Smith, and I represent the Flomes, David and Catherine Flome, who are the appellees in this court. We are asking the court today to please bring some stability to this issue. Last week, in the Marietta Daily Journal, they had a headline on the front page, "More Map Confusion." If this honorable court does not affirm this ruling by Judge Harris, we're going to have a lot more map confusion in not just Cobb County, but in 158 counties, because it's going to allow all these different counties to use home rule.
Well, and Mr. Smith, that's obviously correct in sort of a colloquial sense.
Right.
But whether or not this court has the power to decide the merits of this claim, because this claim is a declaratory judgment claim, there is a large body of precedent that restricts us to deciding the merits only if your clients can show that there is future action they are intending to take and about which they are uncertain and they need clarity. And I don't see what future action they are seeking to take where there is present uncertainty. They have uncertainty about the legal status of existing things. But when they go to vote in 2026, they'll have a voter registration card from the county that says you vote at this polling location. And if they show up anywhere other than that, they're not going to be allowed to cast a ballot, right?
Correct.
So what is the action that they're seeking to take in the future about which they're uncertain? Not is there sort of general uncertainty, because there plainly is, and somebody should probably do something about that, but whether we can do something about it in this case is the question we have to decide.
Well, Your Honor, Justice Peterson, my clients, particularly Catherine, has been a poll worker. She's contributed. She's continued to be active as a activist.
They clearly have a strong interest as members of the community. And that may well be sufficient for constitutional standing, but for the additional declaratory judgment standing to get the remedy of a declaratory judgment, Our precedent is really clear. They have to show there is future action they are seeking to take about which there is genuine uncertainty. And so what I'm looking for is, what is that?
Well, Your Honor's continued uncertainty, Your Honor, is the fact that the county could continue to change the maps. They could continue.
Well, Mr. Smith, under that scenario, when the General Assembly reapportions, decennial reapportionment every 10 years, I mean, those maps through the years are usually subject to legal challenges in federal court, are they not?
They are.
Why wouldn't every citizen, if the Flomes have declaratory judgment standing here, why would not every citizen, post-enactment of even the legislative reapportionment maps, have uncertainty pending the resolution of lawsuits?
Well, Chief Justice Boggs, when usually you only have redistricting every 10 years, and then there's usually a constitutional challenge maybe immediately thereafter. But with home rule, you could theoretically change the maps every time that they don't like.
That doesn't change the uncertainty and the standing question that has been asked both of opposing counsel and now of you as to what is the uncertainty that the Flomes are facing here that every other citizen would not face under similar circumstances.
Well, they were moved from one district. They voted in one district, and then all of a sudden they were in.
It happens every time there's reapportionment. Legislative reapportionment, everybody ends up voting in a different district, it seems.
So what you're describing isn't uncertainty, it's unsettling, but those are two different things. I mean, you know where you are. So when we spoke with the county earlier, you didn't pursue review of the dismissal of the mandamus claim here, right?
Excuse me?
You didn't pursue appellate review of the mandamus. That's not before us. We just have the declaratory judgment.
We did not.
And so what you're describing is this sense of, I'm not certain whether my county can do this, whether they'll continue to do this, and that's sort of this generalized, sort of unsettled state of affairs. But the presiding justice's question, there is a set expectation. I mean, they are operating and saying, this is the map we are using. That doesn't seem to be of the sort of uncertainty that we've talked about in declaratory judgment actions. But to that end, that doesn't mean that the Flomes or any other citizen wouldn't have opportunity, whether it be mandamus, whether it be an action in quo warranto, to challenge what the county has done. It just may be that what we're trying to figure out is declaratory judgment a cognizable way to do that?
Well, we were in court and we had both. We brought both actions. We brought the mandamus, we brought the declaratory judgment action. Judge Harris didn't obviously like the mandamus action, so we traveled under the declaratory judgment action. And that's what we had.
Well, you didn't appeal the mandamus decision.
We did not, because we prevailed under the declaratory judgment, and we felt like we got the remedy that we wanted, which was the judge declared the maps unconstitutional.
Counsel, you mentioned your client or clients continuing to want to advocate and contribute to candidates in the future. Is there any allegation in the complaint that sets that out and sets out a potential harm that they would be facing if this challenge weren't to go forward and they couldn't have the declaration that they seek in the future?
In the amended complaint, Your Honor, we did bring those up and ask that said that would be a future harm.
But I guess what is the future potential harm or risk that they take by advocating or contributing?
Well,
that would be resolved by.
I think for any voter, I mean, you're standing on their right to vote. I mean, civil right of wanting to vote, wanting to participate in the process. You're squishing that, and you're going to have other lawsuits if this is not successful. You're going to have immediate other lawsuits that are going to challenge this, because it's going to create.
Oh, I don't think there's any question that Cobb County is facing any number of lawsuits. I mean, of the nature that we've discussed here. But that doesn't answer the question that's presented by this, which is we don't just get to pick what outcome we want. We have to follow the law. And so what we're trying to get to is under our declaratory judgment precedent, okay, what we have said in the past, what is the uncertainty here? And I hear what you're saying, and I appreciate the argument, but I'm trying to figure out how that maps onto our existing case law.
And to be clear, that's not a question about the merits. That's a question of whether we get to the merits.
Right.
Do you see any appreciable difference between declaratory judgment standing that the Flomes are alleged to have here and presumably declaratory judgment standing that maybe a member of the Board of Elections might have? Is there any appreciable difference that we should be paying attention to? For example, let's add to that hypothetical that the members of the Board of Elections take an oath to uphold the Constitution.
I'm sorry, I didn't hear that last part.
We assume then, for the purposes of this hypothetical, that members of the Board of Elections take an oath to be a member of that board, that they will uphold the laws and Constitution of this state.
Well, certainly that would be an obligation that the Board of Elections would have.
And to the extent they were uncertain about how to execute on that oath, that could inject a level of uncertainty that perhaps is not present with somebody who knows where they have to vote but doesn't like it.
Right, correct. But again, I get back to, Your Honors, I do believe that if you read the FEC versus Aikens case and the other, we cited an Ohio case, I believe those are analogous to the declaratory judgment standards of standing. And I believe they do show the immediate harm that you have to show in the declaratory judgment arena.
But if they get to vote, they still get to vote. If they still get to participate in the process, how are they harmed? I know they don't get what they want, but what is the harm?
Well, again, the harm is maybe they're not harmed in this particular election, but it may be in the future when there's created more uncertainty, because again, we've already got lawsuits that were filed last week, the week before, as soon as right after qualifying, when candidates were thrown out that were disqualified in districts 2 and 3. You've already got chaos. You're going to have more chaos under these two maps. Nobody understands what's going on.
Thank you, Counsel.
And so you're creating chaos.
Thank you. Your time has expired, unfortunately, but thank you both for a fine argument. We'll have your decision as soon as possible. Thank you.